Alright, we on live right now. Hello, salam sejahtera. Sekali lagi kepada semua anda. Saya Moses Pia Ampang bersama dengan tetamu jemputan iaitu Encik Robert Pay yang merupakan Presiden Sabah Sarawak Right Australia New Zealand ataupun nama singkatannya SSRANZ. Saya mewakili NGO Republic of Sabah North Borneo ataupun nama singkatnya RSNB. Pada hari ini kami akan membincangkan beberapa perkara yang perlu diberikan perhatian oleh rakyat negara Sabah dan rakyat negara Sarawak kerana perbincangan ini adalah sangat penting. Beberapa persoalan akan dibangkitkan untuk bersama-sama memahami keadaan yang sebenar. Di dalam sesi video ini, kami akan membincangkan tentang legal ataupun mengenai perjanjian Malaysia dibawakan ke Mahkamah Tinggi Borneo. Itu pertama. Kedua, kami akan membincangkan tentang kenyataan daripada MP Sabah yang telah dipanggil pihak polis. Ketiga adalah berkenaan dengan Setiausaha Agung Parti Bumi Kenyalan telah dipanggil pihak polis untuk memberikan keterangan berkenaan dengan tindakan mengatakan tentang kemerdekaan Sarawak. Seterusnya adalah berkenaan dengan kenyataan bersama yang dilakukan oleh SSRANZ dan juga BOPIM, Borneo Plight in Malaysia Foundation untuk berkerajaan sendiri for self-determination. Dan persoalan-persoalan umum juga akan dibincangkan jikalau anda ingin mengemukakan persoalan anda. Hanya perlu meletakkan komen dan jikalau pihak kami merasakan komen ini wajar diberikan perhatian dan perlu dijawab, kami akan mengetengahkan semasa dalam live video ini. Jadi tanpa melengahkan masa, kita akan meneruskan sesi video kita ini. Good afternoon and thank you so much for joining us this afternoon. We cannot express how thrilled we are to have you all. Today again, I have invited the President of SSRANZ, Mr. Robert Pay, to talk on the filing legal suit in the Borneo High Court regarding MA63 and all the matters that has just been raised. So without delay, I'll pass this to Mr. Robert Pay.
Yes, hello, good afternoon everyone in Borneo. To start today, I will talk briefly on the legal suit that has been filed in the Borneo High Court by 12 litigants on the issues concerning MA63 or the Malaysia Agreement 1963. As I understand it, the 12 litigants are represented by the law firm of Woon and Company Advocates in Kuching, Sarawak, and the suit was filed on about the 25th of November 2021. I may stand corrected on the date. The suit is to seek relief firstly to, among other things, to seek a declaration that the Malaysia Agreement 1963 was invalid, and to seek relief for the loss and sufferings the 12 litigants have experienced from 58 years in Malaysia. The main declaration states as follows. It says, a declaration that the British purported decolonization of Sarawak and Sabah in 1963 by transferring the colonies to the Malayan Federation was not lawfully completed in a manner consistent with the right of the people to unconditionally exercise self-determination as required by the UN General Assembly Resolution 1541 XV and 1541 XV and international law principles, nor in accordance with the Manila Accord 1963, which required that the UK and Malaya to seek consent of the people in compliance with the resolution 1541 to hold a referendum before establishment of the proposed federation and resolution of the Philippines claim on a part of Sabah. So this is the main, one of the main declarations which the 12 litigants are seeking. And I haven't got on hand the full statement of claim at the moment, but we know that the issue of the validity of the Malaysia Agreement has been very widely discussed, and there are a number of issues which we raised last week concerning why it is considered that the Malaysia Agreement as an international treaty was not properly concluded in compliance with international law. And one of these breaches we have been raising since 2013 is that the agreement was void from the beginning because it failed to comply with international law on treaty making. And one of the main requirements is that only independent sovereign states can make binding agreements with each other. And the fact that North Borneo or Sabah and Sarawak were colonies of the Great Britain in 1963 on the date the Malaysia Agreement was signed on the 9th of July 1963 meant that the agreement could not be binding because neither Sabah or Sarawak had the power to make an international treaty. And of course this case was this rule was reaffirmed by the International Court of Justice in the Chagos Islands case in 2019, where it confirmed that the United Kingdom could not make a binding agreement with a colony which was fully under its control at the time the agreement was made. Other issues which are being raised, as I understand, in the statement of claim by the 12 litigants would include the claim that the whole process of forming Malaysia was not consistent with the rights of the North Borneo and Sarawak people to unconditionally exercise self-determination as required by the United Nations rules for decolonization. And further, one very important point which most of us have overlooked is that the Manila Accord signed on the 31st of July 1963 by Malaya and the governments of the Philippines and Indonesia, required that this Philippines claim on Sabah be resolved before Malaysia formation could proceed. However, what happened was that the formation of Malaysia was hurriedly done by the preempting of the UN assessment on the people's wishes in Borneo, when the British government and the Malayan government amended the Malaysia Agreement on the proclamation date from the 31st of August 1963 to the 16th of September 1963, before the UN assessment of the people's wishes was even completed. So in other words, the British and Malayan governments had treated the UN assessment as irrelevant and has no impact on their decision to form Malaysia, as they declared. It would be formed by the 16th of September, even before the UN had completed its assessment. Now, the fact that the Philippines' claim was not resolved on the 16th of September, so this is an issue which remains outstanding. And why and how does this part of the pre-Malaysia condition affect the legitimacy of Malaysia? Well, the British claimed to have transferred sovereignty of North Borneo to Malaya on the 16th of September. However, at the time, the Philippines still had a life claim on Sabah. So how could the British transfer that part of Sabah to Malaya, since it has not or was not resolved that the British had the right to do the transfer? So in other words, the formation of Malaysia was not completed according to the Manila Accord 1963. And that I would say for the moment is all I can comment on the legal suit filed in the Borneo High Court in Kuching recently, and there will be more we can discuss next time when we get the full statement of claim from the people who filed it. However, may I refer to the fact that this filing in a way is connected with the questioning of the Sabah MP Aziz Jaman on the 23rd of November over his parliament statement, which pointed out the fact that there are rising calls in Sabah for secession and independence, together with the strong campaign in Sarawak for independence. The member of parliament was questioned by the police over his statement, I think, which was made on about the 9th of November, and the MP was reported as saying all he did was to raise concerns about what is happening in Sabah, and he said if we want to save Malaysia, we need to implement the Malaysia Agreement 1963. He said he was merely voicing the sentiments of Sabahans on social media about leaving Malaysia if Sabah continued to be sidelined. He further said that in Sarawak, voices were already raised about leaving Malaysia. So a media report also commented that the investigation held against the MP for Sipanga for his statement at the Parliament on the 9th of November 2021 is not only unjust but shamefully unlawful. So and further, I understand yesterday the Parti Bumi Kenyalan Secretary General was also called for a police interview after she posted a video on her speech calling for Sarawak independence a couple of days ago. Apparently, a police report was made against her speech and lodged by a local member of parliament, and subsequently this YB received widespread criticisms on the internet condemning him as an ulun Malaya. And in response to the above developments, the SSRANZ in Australia has issued a joint statement with the Borneo's Plight in Malaysia Foundation on the freedom of speech and Sabah Sarawak's inalienable right to seek separation and independence from Malaysia, which I would like to go through with you today. So if you can bear with me, allow me to go through the various points we have raised.
Sure, please proceed.
Yes, I shall now in our statement, which is headlined Joint Press Statement by Sabah and Sarawak NGOs on the police interview of Sabah MP on Sabah secession and independence. Our statement stated that we express concern over the police interview of the Member of Parliament Aziz Jaman on his statement about growing secession calls within Sabah in Parliament on the 9th of November 2021. Our statement says that this type of policing raises two serious issues confronting the Malaysia democratic system. This being the continuing suppression of the freedom of speech and the inalienable right of Sabah and Sarawak to exit the Federation for Independence, as Singapore did freely in 1969. A heading on parliamentary privilege on freedom of speech and police harassment. We noted that the members of parliament are protected by parliamentary privilege in the Dewan, that is, they have a freedom of speech. It is a special legal status to enable MPs to speak freely on public issues in Parliament, and it is clearly stated under Section 7 of the House of Parliament Privileges and Powers Act 1952 that, quote, members are accorded immunity from civil or criminal proceedings for anything done or said before the House. So it clearly means that what the Sabah MP said should not have been subject to any what I call political policing with the police questioning him on what he said, as this was a freedom of speech protected by Parliament itself. And we assume, although it's unclear, that this questioning had arose from a police report from some overzealous person who didn't like the idea about Sabah and Sarawak exiting Malaysia for independence. We must point out that any police interference in politics violates the United Nations Guide on International Standard Police Procedures. On page 4 of the handbook, Office of the United Nations High Commissioner for Human Rights Professional Training Series, it states that point 1, no member of the police may participate directly in political activities. Point 2, no member of the police may be ordered or forced to exercise his or her functions or powers or deploy police resources to promote or undermine any political party or interest group or any member of such a party or group. Clearly, no one can misuse the powers of the police to serve the political interests of any party or group against any other party or group. When the news of the police questioning was known, an online petition was started and circulated condemning and calling for the police inspector of police to apologize for the unlawful harassment of the MP and calling on the Home Affairs Minister to submit a report on the incident to the House's Standing Committee of Privileges. This questioning has also been criticized and condemned by many social groups and also members of Parliament. So at the same time, it must be added that whoever made such a police report against the MP was doing so in breach of the UN rule by misusing the police to do their political work. Of course, in this case, the Sabah MP had defended himself by saying that he was merely pointing out the fact that there is increasing Sabah dissatisfaction with the implementation of the Malaysia Agreement 1963, which was a treaty signed by Malaya with Singapore, North Borneo and Sarawak, and the United Kingdom. According to a news report on the 24th of November 2021, the MP had stated that he was shocked by the police when he was summoned over his speech. So all he was saying was, if we want to save Malaysia, we need to implement the Malaysia Agreement. Otherwise, they could expect that the discontent and dissatisfaction in Sabah and Sarawak will just rise and rise. In relation to this, the press statement further pointed out that the right to exit any association is a corollary to the right of free association on which Malaysia was claimed to have been founded. This is linked to the fundamental principle of international law that countries have the legal right to unconditionally exercise self-determination under UN General Assembly Resolution 1514. It is therefore not unlawful to openly call for Sarawak or Sabah independence. In reference to the MA 63 Intergovernment Committee, Chairman of the IGC, Lord Lansdowne, in 1963, in responding to calls for an exit clause in the treaty and federal constitution, said this was not necessary as any state voluntarily entering a federation had an intrinsic right to secede at will. This exit right is a well-established principle of international law by which the United Kingdom itself successfully exercised in its referendum vote on Brexit in May 2016 to exit the European Union. And even Scotland, which has been a part of the UK for over 300 years, have sought independence by holding a referendum vote to exit the United Kingdom. And back in 1922, Ireland, which was colonized by Great Britain more than 250 years ago, also separated from the United Kingdom and became independent. And it might be mentioned that 9 days after the Malaysia Agreement was signed on the 9th of July 1963, it was reported by the Borneo Times on the 18th of July 1963 that the Tengku, being the Prime Minister Tengku Abdul Rahman, was serious when he announced that the territories that came into Malaysia were free to leave the Federation if the new country did not bring any benefit to them. Prime Minister Mahathir also, the former Prime Minister Mahathir also made a significant acknowledgement in 2018 that MA 63 does not prevent the Sabah Sarawak people from asking for independence, which he had qualified by saying they only wanted autonomy and not independence. Our press statements states that therefore any law passed to penalize citizens for raising this subject would only confirm that the formation of Malaysia was not free and voluntary and in breach of international conventions on the right of secession and independence. We say that the call for secession and independence have arose from the widespread dissatisfaction in Sabah and Sarawak over the non-compliance with an illegal removal of entrenched Malaysia Agreement promises and guarantees or terms and conditions agreed to by Malaya in 1963 to convince the Borneo people to give up independence for federating with Malaya and Singapore. One of these failed promises was what the late Prime Minister Tunku Abdul Rahman stated was a prime Malaysia formation objective, which was to eradicate poverty and develop and advance the Borneo territories. However, we all know that by 1976, all the entrenched foundational terms were removed by unlawful constitutional amendments under Act 354, including the inalienable right to 34.5% of parliamentary seat allocation to Sabah and Sarawak after Singapore exit, and religious freedom. The removal of these rights came not long after the illegal federal seizure of Sabah and Sarawak petroleum resources in 1974 under the Petroleum Development Act. Another MA63 fundamental term for Borneoization of Sabah and Sarawak civil services has been totally replaced by Malayanization, which is locally called colonization. Again, we must acknowledge that Sabah and Sarawak dissatisfaction have propelled the Sabah and Sabah governments to seek redress on the so-called erosion of MA63 rights. However, the discontent has increased with the lack of transparency and accountability to the public on the MA63 discussions, which began in around 2016, and after the MA63 report was declared a state secret in 2018, and the poor handling of the MA63 negotiations by both federal and state governments. It is absurd that the MA63 report should be declared a state secret, since it is a matter that affects every Sabahan and Sarawakian since 1963, and they have a right to know why their future is again determined by others without their approval and discussion. Most aggravating was the failure after 5 years to deliver any real results other than to compromise Sabah and Sarawak rights, especially on surrendering the petroleum ownership rights to Malaya. Further, it is mentioned in the press statement that Sabah activists have pointed out that the MA63 consultative committees are unconstitutional, as they do not comply with Article 112D(6) of the Federal Constitution, which stipulates that if any review of the federal government and the government of a state are unable to reach agreement on any matter, it shall be referred to an independent assessor, and his recommendations shall be binding on the governments concerned and shall be given effect as if they were the agreement of those governments. Well, I mean, it's fine for that there is such a requirement. Firstly, we note that both the federal and state governments have not brought up this issue and have quietly continued with their so-called negotiation as if even though they couldn't agree on apparently 4 major issues, and they have failed to refer the matter to an independent assessor. As to the question of an independent assessor, we must look at this carefully, because who could be appointed as an independent assessor who would not have any conflict of interest or bias in producing a result on which would bind both the governments. The question is, should we call in independent assessor from the United Nations? Because this involves the matter of an international treaty. So perhaps it would be only fair when this is done. And in that case, the United Nations should take the opportunity to review the whole implementation of the Malaysia Agreement, and at the same time reopen the process on which MA63 and the formation of Malaysia was concluded. In other words, the United Nations will have an opportunity to revisit MA63. However, perhaps it is because of such implications that the federal and state governments are not prepared to have an external examination of MA63. So it certainly comes to the question of Sabahans and Sarawakians taking the initiative to open up the issue. So in Sarawak, 12 litigants are taking this matter further by filing a joint legal suit against the governments of the United Kingdom, Malaysia, and Sarawak, seeking declarations that MA63 was null and void, and seeking damages for consequent pain and suffering and loss arising from the unlawful incorporation of Sabah and Sarawak into the Malayan Federation, and consequential damages from illegal expropriation of their natural resources, especially petroleum resources. The full details of the suit will be discussed further in our forthcoming broadcasts, and we hope we may be able to include include some of the parties or their legal advisors to join in the discussion. The press statement conclude that if MA63 was validly made, then it has been terminated by 58 years of fundamental breaches, and it is no longer binding on Sabah and Sarawak. The press statement then concluded by calling on the federal government to commence negotiations with the Borneo state governments on the separation of the two territories for independence, which the people most strongly aspire to, and as was similarly amicably agreed to by with Singapore in 1965. That's the end of the gist of the statement, and perhaps Moses, would you have any question to raise on that? Your mic is muted.
Sorry. All right. I will translate the whole message in a very short message, if possible, in bahasa. Hold on. Give me a second. All right. Sebentar tadi, Encik Robert Tay telah menerangkan dengan panjang lebar tentang beberapa perkara, iaitu perkara pertama, Parti PBK, Parti Bumi Kenyalang telah memfailkan suit ataupun saman di Borneo High Court, Mahkamah Tinggi Borneo di Kuching tentang kesahihan perjanjian Malaysia ini. Jadi tindakan ini adalah untuk memastikan bahawa perjanjian Malaysia ini sah pun tidak, tetapi berdasarkan kepada analisis, berdasarkan kepada kajian yang telah dilakukan, sememangnya perjanjian Malaysia ini tidak sah. Jadi implikasi kepada tindakan uh, kumpulan ini yang telah memfailkan saman akan dapat diketahui apabila mahkamah bersidang nanti. Untuk perkara kedua adalah berkaitan dengan MP, iaitu Dato' Aziz Jaman yang telah dipersoalkan selepas beliau memberikan kenyataan di Dewan Parlimen tentang keinginan rakyat negara Sabah ingin berpisah ataupun berpisah daripada persekutuan jikalau perjanjian Malaysia ini tidak ditunaikan. Seperti yang sedia maklum, Dewan Parlimen merupakan tempat di mana tidak ada sekatan dikenakan ke atas wakil-wakil rakyat, disebabkan setiap ahli parlimen mempunyai imunisasi terhadap sebarang dakwaan. Tetapi yang peliknya apabila ahli parlimen daripada Sabah telah membangkitkan perkara ini yang hanya sebagai medium untuk memberitahu Dewan Parlimen, beliau telah dipanggil polis dan tindakan ini dilihat sebagai tindakan untuk menakut-nakutkan ataupun memberikan mesej yang jelas bahawa jangan sesekali menyebut perkara ini. Ini yang macam orang cakap membuli, okey, menakutkan. Jadi tindakan ini sangat-sangat dikecam kerana apa yang beliau lakukan adalah untuk menyuarakan hasrat rakyat dan sememangnya perkara itu adalah benar. Tetapi kenyataan Dato' Aziz Jaman ini telah menyebabkan mereka tidak selesa kerana wujud kekhawatiran ataupun kerisauan bahawa tindakan beliau itu hanya akan membangkitkan lagi sentimen ini dan sememangnya itulah yang sedang berlaku. Ketiga adalah berkaitan dengan Setiausaha Agung Parti Bumi Kenyalang yang telah dipanggil oleh polis untuk disoal siasat setelah beliau secara terang-terangan memberitahu di dalam video bahawa untuk Sarawak mencapai kemerdekaan, kita memerlukan sejumlah ramai ahli calon, iaitu sebanyak lebih kurang 100 lebih untuk memenuhi adun Sarawak. Apa yang kita boleh lakukan ialah kita melakukan deklarasi UDI ataupun Unilateral Declaration of Independence, okey, di mana perkara ini juga terbukti berkesan apabila beliau menggunakan contoh yang berlaku di Kosovo, yang mana Kosovo ahli parlimen ataupun ahli undangan mereka telah bersetuju untuk merdeka, dan apa yang mereka lakukan setelah undian dilakukan, semua ahli parlimen di Kosovo bersetuju untuk merdeka, berpisah, dan mereka telah melakukan permohonan di United Nations dan ICJ telah memutuskan bahawa tindakan itu tidak menyalahi sebarang undang-undang antarabangsa dan ia diperbolehkan. Jadi apa yang Setiausaha Agung PBK iaitu Priscilla Lau lakukan ialah memberikan kesedaran. Namun begitu, tindakan polis yang telah memanggil beliau dilihat sebagai satu tindakan untuk menakut-nakutkan pemimpin-pemimpin ataupun calon-calon parti PBK agar tidak menyuarakan perkara ini. Tetapi kita sedia maklum bahawa wujud pelbagai cara untuk memerdekakan dan PBK memilih untuk melakukan secara berperlembagaan, mengikut saluran perlembagaan kerana ia bukan satu kesalahan. Okey, yang perkara seterusnya ialah SSRANZ telah melakukan kerjasama dalam mengeluarkan kenyataan untuk mengecam tindakan pihak kerajaan yang telah untuk memberi tekanan politik kepada ahli-ahli Parlimen Sabah untuk tidak menyuarakan perkara yang berkaitan dengan kemerdekaan ataupun perjuangan kemerdekaan ataupun yang apa-apa berkaitan yang berpisah. Kerana kenyataan itu mereka khawatiri akan membangkitkan lagi ini sentimen. Tetapi sebenarnya apa yang berlaku, tidak ada peraturan ataupun undang-undang yang melarang kita untuk menyuarakan hasrat tersebut disebabkan persekutuan Malaysia ini dilakukan secara voluntary berdasarkan penerangan Encik Robert Pei, dan sudah tentunya perpisahan ini juga boleh dilakukan secara intrinsik dalaman, dilakukan secara sukarela. Jadi tindakan ini untuk mengecam ataupun menakutkan wakil-wakil rakyat ini adalah satu tindakan yang sangat menyedihkan, dan kita memberikan sokongan kepada MP yang bersuara untuk rakyat Sabah dan Sarawak. Kerana kita berhak untuk merdeka, kerana tidak ada larangan untuk merdeka, dan juga di dalam perlembagaan Malaysia tidak ada sebarang artikel yang mengatakan Sabah Sarawak tidak boleh merdeka, kerana ini dibuktikan apabila Singapura telah berpisah daripada Malaysia dan menjadi negara yang merdeka dan berdaulat. Okey, jadi itulah secara rumusan apa yang beliau katakan, dan kami mengalu-alukan sebarang persoalan yang anda ingin sampaikan supaya kita boleh berbincang. Dan sebelum itu, ada persoalan yang ingin diberikan kepada Encik Robert. Mr. Robert?
Yes.
Just give me a second. There's one question that I wish to ask you. If Malaysia is not legally formed, why all countries around the world recognize Malaysia? Do you have anything to say about this one? Thank you.
Yes, I think just let me pull out some notes. Yeah, the question of regarding the recognition of Malaysia, we should look at it in the historical context about what happened in 1963. This question has been raised often in response to the nationalist position that Malaysia was an illegitimate neo-colonial creation without the people's consent, and federalists or people supporting Sabah and Sarawak Federation with Malaya have argued that if it was illegitimate, why do governments recognize Malaysia as a new nation in 1963? The answer is that at the time there was no need for any country to formally recognize Malaysia, as it was merely a name change for the Malayan Federation. So in other words, the Federation of Malaya had merely changed its name to the Federation of Malaysia, which didn't involve the formation of a new nation or a new country. According to the rules of the United Nations and Convention of International Law, only a new nation requires recognition by other states. under international practice, which the recognition basically means that the new nation has acquired an international personality which will allow this new nation to be equal to all other states in their international dealings. And you could firstly try to define what is a state. Under the Montevideo Convention 1933, the definition of a state was given as that state is the international personality which possess certain requirements, including a government, a defined territory, a defined population, and the ability to enter into relations, international relations with other states, other sovereign states. So Malaya in 1963 was already an independent state, which gained its independence in 1957 after the British grant the Federation of Malaya independence. So on the proclamation of Malaysia on 16th of September 1963, Malaysia was in reality an existing personality. Nothing had changed. They were still using the same constitution with some amendments to admit 3 additional members: Singapore, North Borneo, and Sarawak, as described by the United Nations legal opinion dated 19th of September 1963. And the Malayan UN representative Dato' Ong Yok Lin wrote a letter to the UN General Assembly dated 16th of September 1963, confirming that no new nation was created, but just a name change for Malaya. This was endorsed by the Secretary General of the United Nations, Uthan, and at the same time, the UN provided a legal opinion on the 19th of September 1963 in response to the United Kingdom's question on Malaysia whether a name change required a fresh application for UN membership. And the opinion confirmed that countries could change their name, but they are still legally the same international person. Therefore, there was no need to apply as a new UN member. The legal opinion at the same time had noted that 3 territories were new additions to or acquisitions of territories by the Federation. Thus, North Borneo and Sarawak were very smoothly handed over or annexed by Malaya without huge opposition by UN members, because they bypassed the stage of opening up admission of a new member, because Malaysia was not a new nation and there was no need to apply for new membership, and consequently it avoided the scrutiny of the UN General Assembly and also the Decolonization Committee. For this reason, it was logically unnecessary to seek international recognition of Malaysia. Since Malaysia was just a name change from the Federation of Malaya, it bypassed the need to seek international recognition, since Malaya had already become independent in 1957, and underlying this approach, we need to understand, in relation to the so-called recognition of Malaysia, we need to understand that this was a strategy adopted by the British government to avoid criticism and opposition to the application for new UN membership, which would have arose from a great number of UN members who had condemned Malaysia as a new colonial plan. And this was this sort of events or facts have generally been hidden from the people of Malaysia. The British strategy did not require a fresh application for UN membership as a new nation, and the British reason was clearly stated in their declassified papers, and such intention have been stating their documents have been reproduced in books on Malaysia. In relation to the recognition of Malaysia, federalists or pro-Malaysia people argue that due diligence by the Security Council and or the General Assembly was done in full compliance with the UN General Assembly Resolution 1514 and 1541. Well, this must be thoroughly denied. Firstly, we must note that the UK never submitted the decolonization of North Borneo and Sarawak to the United Nations Decolonization Committee, because it took steps to avoid this by proposing the Malaysia plan to integrate the colonies into the Malayan Federation without seeking the people's consent, the people's informed consent in a referendum. That means compliance with Resolution 1514 require that the people of a country should freely and unconditionally exercise their legal right of self-determination or independence. However, the British government was imposing an external condition on this right by proposing the Malaysia Plan instead of granting independence first and allowing the people of independent North Borneo and Sarawak to choose federation with Malaya or remain independent after that. So in other words, the British had imposed an external condition without even the knowledge of the North Borneo and Sarawak people by proposing to include their countries by integrating their countries with the Federation of Malaya. The initial reaction, as we know, was a lot of opposition to the idea of Malaysia. But it is claimed that the British were decolonizing Sabah and Sarawak in compliance with the United Nations General Assembly Resolution 1541. This again must be denied, because to comply with this resolution 1541, the people must be able to freely exercise their legal right to self-determination unconditionally, with informed consent on the Malaysia question. And we all know that the Malaysia proposal came from Malaya and the United Kingdom in 1961, and this was never anything considered by the people of North Borneo and Sabah. All the time they were believing that the British would grant them independence as promised when North Borneo and Sarawak were annexed by the British as crown colonies in 1946, I beg your pardon. This means that to comply with Resolution 1541, there must be a period of education and information to fully inform the people and to allow them to achieve political maturity with self-government, so as to enable them to make an informed decision on federation. However, if we know our historical dates, we must note that North Borneo and Sarawak were only given so-called self-government on the 31st of August 1963, which is 14 days before proclamation of Malaysia on the 16th of August, September 1963. So in other words, how would that comply with the UN Resolution 1541, which required that the people gain experience in government? How would they gain experience in self-government within 14 days? This is described as a joke by the Indonesian government, and naturally the government of Indonesia and the Philippines opposed Malaysia for the very reason that there was no legal basis for the formation of Malaysia, especially when there was no referendum to gauge the people's wishes on federation. In relation to the so-called due diligence, which was done by way of the UN assessment of the Borneo people's wishes, it must be mentioned that the UN Secretary General had actually breached UN rules, that the UN Secretary General must act independently and not act on the instructions of members. But the UN Secretary General actually didn't act independently because it accepted the UK government's directions to conduct a so-called assessment instead of holding a proper referendum on the wishes of the people. This again, we say again that this was done by the British government, which wanted to avoid scrutiny by the United Nations Decolonization Committee, and of course, if the Decolonization Committee was involved, it would obviously require a proper referendum. A referendum was also the legal requirement which the British governor of North Borneo, Sir William Good, observed in a secret, now declassified document, that there should be a referendum. The UK government had feared that in holding a referendum they would be likely to lose the vote. And at the same time, the British had discussed with the Malayan government on how to avoid a referendum and how to avoid scrutiny of the United Nations Decolonization Committee. The most revealing declassified document was conveyed by UN officials to the United States and UK government, that the UN would select a hand-picked team that would assure the outcome of the assessment would be in favor of the Malaysia plan. So this is evidence that there was collusion between the UN Secretary General's office and the United Kingdom to abuse the right of self-determination of the people of North Borneo and Sarawak. I think that's the background to the recognition of Malaysia. The Indonesian and Philippines government had actually refused to recognize Malaysia when it was proclaimed on the 16th of September 1963 on the grounds that the terms of the Manila Accord and the UN Resolution 1541 had not been complied with. This led to the escalation of confrontation, and on the issue of confrontation, it would involve more discussion in another broadcast. So I would conclude on the fact that recognition argument is not valid in the sense that there was no need for countries to recognize Malaysia, since Malaysia was merely a name change for Malaya, and that the structure of Malaya was merely the membership of the Malayan Federation was expanded by inclusion of 3 new members. However, they continue to use their same constitution, and actually this is a big contentious issue between the federal and the Borneo states currently, because it is alleged that if Malaysia was a new nation, there should have been a new constitution. So in other words, what is being said confirms that no new nation was created, and therefore there was no need to recognize Malaysia. It was already recognized as the Federation of Malaya with a name change.
I see.
That's all I have to say, really. Thank you.
Thank you, Mr. Robert. Okay, I will translate in bahasa. Okey, sebentar tadi kita telah mendengar penjelasan yang panjang lebar daripada Encik Robert Pei mengenai persoalan, iaitu jikalau Malaysia ini tidak sah, mengapa semua negara di dunia mengiktiraf Malaysia? Ini adalah persoalan yang perlu difahami. Pertama, Malaysia bukanlah sebuah negara baru. Mengapa? Kerana Malaysia adalah nama yang digunakan ataupun nama penjenamaan semula yang digunakan pada 16 September 1963. Ini kerana identiti Malaysia itu sebenarnya adalah Melaya yang terbentuk pada tahun 1957. Ini juga dapat disahkan melalui perlembagaan yang digunakan sehingga sekarang. Jadi persoalan dia ialah untuk apa negara luar mengiktiraf Malaysia jikalau ia hanyalah uh, pertukaran nama ataupun penjenamaan semula, sebab Melaya Malaysia itu sudah wujud dengan identiti lama iaitu Malaya. Jadi tidak ada keperluan untuk mengiktiraf Malaysia, tetapi ia hanyalah uh, UN hanya memaklumkan kepada seluruh dunia bahawa Malaya telah menukar nama kepada Malaysia atas sebab kemasukan Sabah Sarawak Singapura ke dalam Persekutuan Tanah Melayu dan mereka telah menjenamakan kepada Malaysia. Tetapi perkara ini tidak dimaklumkan dengan secara terang-terangan kepada rakyat Sabah dan Sarawak pada waktu itu kerana kita dimaklumkan, diyakinkan bahawa negara baru terbentuk pada 16 September. Tetapi sebenarnya itu adalah satu penipuan yang sungguh menyedihkan dan adalah satu kemarahan yang kuat apabila kebenaran ini terdedah. Dan juga untuk pengetahuan anda semua, sejarah yang diajar di sekolah berkenaan dengan Malaysia ini dibentuk dipersetujui oleh rakyat itu sebenarnya adalah omongan kosong, adalah tidak benar sama sekali disebabkan fakta-fakta yang diperoleh daripada dokumen kolonial semua tidak menyokong dakwaan ataupun sejarah yang disampaikan di buku sejarah sekolah. Ini kerana Malaysia bukan sebuah negara baru seperti yang diperkatakan tadi, ia adalah nama baru yang digunakan pada 16 September bagi mengaburi niat mereka untuk menguasai Sabah dan Sarawak secara politik, melebarkan kuasa persepadanan politik, dan inilah yang menyebabkan kerajaan Filipina dan Indonesia menentang sehingga membawa kepada konfrontasi. Manila Accord atau perjanjian Manila mahu Malaya untuk memberikan rakyat Borneo, North Borneo, peluang untuk membuat keputusan sama ada mau menyertai Melaya ataupun tidak, tetapi perkara itu tidak dilakukan dan ini yang telah menyebabkan Filipina dan Indonesia tidak mengiktiraf Malaysia ataupun Malaya, pembentukan Malaysia, kerana mereka percaya tindakan tersebut sebenarnya adalah satu bentuk penjajahan baru, yang mana ternyata kenyataan mereka itu adalah benar apabila dokumen kolonial diklasifikasikan ataupun level kerahasiaannya terbuka untuk rujukan semua orang. Jadi ini adalah satu konspirasi politik yang berlaku pada tahun 1963 dan atas sebab itulah mengapa gerakan kemerdekaan sangat kuat sehingga sekarang. Dan untuk pengetahuan anda juga, untuk Sabah dan Sarawak, proses perjuangan kemerdekaan sedang giat dilakukan kerana kita percaya bahawa kuasa kemerdekaan dan kuasa kedaulatan itu adalah milik Sabahan dan Sarawakan dan bukan milik Malaya. Jadi setakat ini tidak ada persoalan yang ingin diajukan. Jadi saya fikir sudah sampai masanya untuk kita menyimpulkan perbincangan pada hari ini, yang mana kita telah meliputi, membincang, merangkumi pelbagai topik yang berkaitan dengan perjanjian Malaysia, tindakan pihak polis memanggil wakil rakyat Sabah. Ini tindakan pihak polis memanggil Setiausaha Agung PBK dan juga kerjasama dalam memberi kenyataan kepada tindakan Malaysia yang cuba untuk membuli ahli-ahli parlimen Sabah. Mr. Robert, do you have anything to say before we close the live video?
I think we've covered the main topics today. We can discuss further in the next broadcast on any issues that are current, and obviously we need to look at the statement of claim by the 12 litigants in Sarawak on the MA 63 validity legal suit, and if we can maybe invite the lawyer who filed the suit to talk about it at one stage, it might be very useful to understand further what is happening.
Sure.
And well, it's only yesterday I learned that the Secretary General of the party Bumi Kenyalan was apparently called by police for an interview. It hasn't yet taken place, but the news has already come out that this it was done on a police report done by a local minister, YB. YB is what? Just a member of DAN, right?
So it was done by, it was lodged by the Sarawakian YB as well, yeah? I see.
So we need to get further news or update on this one, and we can report on it. And so maybe in coming broadcasts we can, give summary of news on Sabah and Sarawak, on what's happening and what is developing on the struggle for Sabah Sarawak independence, especially with the coming elections in Sarawak. It would be interesting to see where the public is on the issue of Sarawak independence.
Sure. All right. Sure.
Yep.
So I think that will end our live video. So we will meet again next week with more news.
Yes. And
All right.
thank you all for listening in, and we hope to talk to you again very soon. Bye.
All right. Thank you. Bye bye.
Thank you.